Good morning and welcome to our annual Immigration Update, November 2024. Thank you for joining us this morning. We have some interesting topics to cover and a number of polls to help make the session a little bit more interactive for you. First, let me take you through some housekeeping points. This webinar is being held remotely, so please do bear with us should we experience any technical difficulties. We will aim to resolve them as swiftly as possible. Our webinar will be an hour, with approximately 10 to 15 minutes at the end for you to ask as many questions as you can. All attendees will remain on mute throughout the course of our presentation. If you have any questions, please add them to the chat box on the platform and we will try and get to as many of these as possible at the end of our webinar. Any questions we cannot answer, we will follow up with you on email afterwards. There will be some polls throughout the webinar, so please get involved with these. The slides will be available to you afterwards. My colleague will send them together with an update and our feedback questionnaire after the webinar. We will also have a short survey, which will pop up automatically at the end of the webinar. Your feedback will help us with the planning of future events and topics. And as a thank you for completing this feedback, we will add those to a prize draw for a £50 John Lewis voucher, which may come in useful for your Christmas shopping. So first, let me introduce ourselves. I'm Imelda and I'm head of the immigration team at Field Seymour Parks. I've been with FSP for just over 5 years now. Today, I will be joined by my colleagues, Victoria and Callum, who both work as solicitors in the immigration and employment teams. For those of you who don't know Field Seymour Parks, we are a full service law firm based in the centre of Reading. We have over 100 staff and we service clients all over the UK. However, many of the firm's regular clients are based in the Thames Valley corridor. Immigration is slightly different, however, as many of our clients are national or even based overseas. FSP offer a tailored approach to clients, primarily offering practical legal advice. We offer free seminars, webinars and podcasts at regular intervals throughout the year across most of our practice areas. We also offer bespoke training or workshops for complicated processes such as right to work compliance, sponsor compliance. And finally, we offer an administration service to assist registered sponsors with the management of their sponsorship management system and their migrants' visas. So please do let us know if you need any information on this or any of our other services. Our topics for today. Victoria will initially discuss the imminent switch to eVisas and how this will impact employee and their employers. Then Callum will discuss right to work checks and how the eVisa changes will impact these checks. Then I will talk about compliance for speculative and registered sponsors. And then I will finish off our presentation with some of the proposed changes for 2025 and beyond. Now, over to you, Victoria, for eVisas.
Thank you, Imelda. Good morning, everyone. As introduced by Imelda, I'm a solicitor here in the Employment and Immigration team, FSP. I'll be discussing one of arguably the biggest changes this year impacting both sponsors and migrant workers, which is the move to an online electronic visa system. Say goodbye to the BRP. Now, these changes have been in the lineup for some time. Some of you who attended our annual update last year might recall that we had discussed the Home Office plans to move away from physical documentation as proof of visa status and the demise of the BRP card system. So this is all part of the move to an electronic visa system. The Home Office are phasing out biometric residence permits, biometric residence cards, and other passport endorsements, so stickers, wet ink stamps, in favour of the new digital eVisas. So some of you recall that the BRP was originally introduced back in 2008 to act as proof of an individual's immigration status and right to work in the UK. Traditionally, an applicant would receive a vignette stamp in their passport and they would then be required to collect their BRP on arrival in the UK. So as many of you who may have applied for visas yourselves or on behalf of others will know, that those who have been issued with BRPs over the past year or so have all had an expiry date of the 31st of December this year, even where the migrant's permission to stay in the UK is for a longer period. Even those that were issued in recent weeks have had the same expiry date. This has caused some confusion for many. However, it's important to be clear that this date is in no way connected to the expiry of an individual's visa, just the BRP card itself. In fact, most recently, the Home Office have confirmed that no more BRP cards will be issued after the 31st of October. This will mean that for those of you who applied for their visa before this date and are still awaiting an outcome, it may be that you do not receive a BRP card, and we need to ensure that your eVisa is correctly set up and linked on your UK VI account. All BRPs will be replaced with eVisas by the 1st of January 2025. From this date, BRPs and other physical documents will no longer be valid proof of your immigration status and/or your right to work in the UK. However, passports are still acceptable forms for UK and Irish citizens. So where does this leave the BRP? Well, the Home Office recommends that migrants retain their BRP for record-keeping purposes, even after its expiry on the 31st of December 2024. They're also recommending that if you're planning to travel, you bring your BRP card with you on all overseas travel until the 1st of January 2025 to avoid any delays at the border. So moving on to the next slide then, we're going to consider what is the eVisa. So the eVisa is an online record of a migrant's immigration status and the conditions of their permission to enter or stay in the UK. Migrant workers will need to create a UK VI account to be able to access their eVisa if they don't already have one. Updating a physical document to an eVisa doesn't affect immigration status, as we said before, nor does it impact the conditions of your permission to enter or stay in the UK. So migrants will be able to travel to the UK together with their current passport, which must be linked to their UK VI account. As before, the Home Office recommends that migrants continue to carry their physical document where they still have it. The Home Office believe that the new electronic system carries plenty of benefits. Firstly, they are considered to be more secure and cannot be lost, stolen, or tampered with like physical documents. Migrants will no longer need to wait for or collect a physical document after their application is decided, although they may still be required to provide biometric information in person, but again, this isn't always necessary. It's thought to be quicker and easier to prove status at the border and share immigration status with third parties, like employers and landlords. One of the other benefits is that selected government departments and authorities can securely access the immigration status information. So examples of these government departments include the Department for Work and Pensions and the NHS. So migrants will no longer be asked to present proof of status when they seek to access those services. So moving on to the next slide. How do I get one? So the Home Office have been contacting migrant workers over recent months to ask them to set up their UK VI account and access their eVisa. But now you don't need to wait to hear from them, from the Home Office, before doing so. You can go ahead yourselves. So for migrants who already have a UK VI account, for example, those that applied through the EUSS, or who use the ID app when applying for their visa, nothing should change and you may already have access to your eVisa. You'll just need to make sure that your UK VI account is updated with your most recent contact details and your passport details. For those with BRP cards, you'll need to create a UK VI account. You'll then be required to complete an online form and you may be required to prove your identity via the app. You'll need access to a smartphone, a mobile phone number, an email address, and your BRP card. If you don't have one, then you'll need a valid passport with your BRP number or your visa application number. You will be asked for some details about your BRP card, including expired ones, and once you've inserted some details, you'll be asked what document you wish to use. And for most, this will be the BRP card. The steps required to create the account are relatively straightforward. However, there are guidance notes if you require assistance, and you can contact UKVI if you run into any tricky issues. You'll then need to sign into your account before you can view your eVisa or apply for one if you need one. You will need your identity document number, so your BRP number, for example, your date of birth, and access to your phone and email before you sign in. Once signed in, there will be a Forms tab along the top of the screen, and there'll be an option to link your eVisa to your account. If that form doesn't show, and it has been that it hasn't for everyone, Try it a few times, log in, log out a few times, and if it still doesn't work, you might need to contact UKVI. Once you can access it, you can click Start, and you'll be taken through the form. The first thing you'll need to do before completing the rest of the form is to complete the Check Your Identity tab through the Identity app. It likely will not let you complete the rest of the application without first completing this stage. Once you've completed the form, you should receive an email from UKVI confirming its submission. Now, it can take a little while for this email to come through, but in other cases, it's automatic. It really does depend. Once confirmed, you'll be able to view the details of your eVisa online or through the app, and you'll also be able to sign in and access the View and Prove service to access your eVisa. If the details on the eVisa are wrong, you should report them to UKVI as a matter of urgency, who aim to currently reply within 10 working days. For migrants who do not have a valid passport and were granted permission to stay after the 31st of October, then the Home Office have said that they are creating accounts for them, and they will be sent an email or letter with instructions as to how to access it. Now, since the cessation of printing BRPs on the 31st of October, some immigration practitioners have noticed some snagging issues. So as before, the Home Office suggested that it is possible to get set up an eVisa account using a unique application number. However, it's not always possible to progress the eVisa form without scanning that ID document. This has led to some complications as to how those without an ID document can set up their eVisas. It is likely that these issues will be raised directly with the Home Office, and we might see an update in this regard shortly. In any case, it is very important that migrants keep their UKVI account up to date with their details, because this could have an impact when travelling if your up-to-date travel document is not consistent with your eVisa. So considering other physical documents then, if a migrant has indefinite leave to enter or indefinite leave to remain and currently proves their immigration status through a different type of physical document, such as a wet ink sticker or a vignette, then they are advised to make a no time limit application, an NTL application. Once decided, the migrant will receive an eVisa and will be told how to access it in the decision email or letter. And from the 31st October, given that they're no longer being printed, NTL applicants will no longer receive a BRP first. Now, there are certain eligibility requirements to make an NTL application, and these can be found at the new guidance, which I have hyperlinked on this slide. So if you do download and you receive after the end of this webinar, you receive a copy of the slides, you'll be able to access the new NTL guidance there. And what if I'm making a new application? So if you're planning on submitting a visa application or you're waiting for an outstanding application, then we'd just recommend that you hold off accessing your eVisa for the time being, just to avoid any confusion over the document being used to make your visa application. It's likely that you'll be granted automatically an eVisa if your visa application is successful, but the important takeaway is that this must be done before the 1st of January 2025. So what should employers be doing now? And we'll move on to the next slide. If you haven't done so already, we would recommend circulating some communication to your migrant workers regarding this change. We expect that the Home Office has already been in contact with most employees by now regarding this change, but it's possible they may not know about it. Any communication should refer to what is changing, what they'll need to do, and ways in which you as an employer can support them in doing it, or at least point them to the Home Office guidance. If you're a larger employer, you might want to consider circulating this information on a wider platform. For example, you may have an intranet accessible by all employees where you can publish an article or even circulate some information that way. And we can help you with providing a suitable communication for your migrant workers if you require it. So we're going to consider our first poll. So after which date will physical documents no longer be used as evidence of immigration status for migrant workers? Now, if you'd like to vote for your options, this is slightly tricky. I think there will be a tie between two options here. I'll give you a moment. Great, so everyone mostly has voted for the 31st of December, which is correct. Obviously, this is when most BRPs are going to expire and the date after which we cannot no longer use them as evidence of immigration status. And from the 1st of January, it will be eVisas that are used in that respect. So returning to that slide then, the remaining point really is that if you are an employer, you may need to repeat your right to work checks for all migrant workers who obtain an eVisa, which leads us nicely onto our next topic. And I'll now pass you over to my colleague Callum, who will be discussing right to work checks.
Thanks, Victoria. Hi all, as Imelda said earlier, my name's Callum. I'm a solicitor in Field Seymour Park's immigration and employment teams, and I'm going to be talking about the important issue of right to work, including what right to work is, how to carry out your right to work checks correctly, and the potential consequences for getting these checks wrong. So to start with, what is right to work? Well, right to work is what it says on the tin. It's the right to do work in the UK. And there are various ways that an individual can have the right to work, but there are three main ones that you're most likely to come across. So the first way is through citizenship. Now, of course, a British citizen has the right to work, regardless of how they acquired their citizenship, but Irish citizens also have the right to work under what's called the Common Travel Area Arrangement, and that's a long-standing arrangement between the UK, the Crown Dependencies, and Ireland, which predates British and Irish membership of the EU. An individual will also have the right to work if they have indefinite leave to remain in the UK, which is sometimes called settled status. And indefinite leave to remain allows the holder to remain in the UK without any restrictions and is ordinarily acquired after living and working in the UK for a continuous period of 5 years. And an individual may also have the right to work under the terms of their visa, though this may be subject to certain conditions, such as maximum working hours or only working in certain roles. And individuals can also derive their right to work from other less common sources, such as the EU settlement scheme, the Commonwealth right of abode, refugee status, and so on. As an employer, you must ensure that you carry out right to work checks on your employees to confirm that they have the right to work. Employers must not discriminate against employees who they feel do not look British or Irish by only carrying out checks on them. Right to work checks must be carried out on all prospective employees. Now, further to guidance that was published in September of this year, employers who hold a sponsor license must also carry out right to work checks on self-employed workers and agency workers and keep records of these checks in order to comply with their sponsor duties. As for the timing of these checks, employers must carry out their right to work checks before the employee commences work. Where the employee is on a time-limited visa, the employer must also repeat the right to work checks at the end of the visa to confirm whether the employee still has the right to work going forward. And touching on Victoria's earlier comments on eVisas, if you have employees who prove their right to work using a document like a biometric residence permit, and they've since transitioned across to an eVisa, then you must repeat your right to work check using the employee's eVisa. And this should be done as soon as possible after the employee gets their eVisa. So since October 2022, there have been 3 types of right to work check that employers can carry out. These are online home office checks, manual checks carried out in person, and checks using an identity service provider. If an employer carries out one of these checks in accordance with the guidance and the code of practice, then they will establish a statutory excuse, protecting them from right to work related penalties, which we'll get onto later in the talk. Employers don't need to obtain any documents to carry out the online home office checks. All they require is for the individual to provide their date of birth and share code. The share code is generated by the individual either by accessing their eVisa or by inputting details from their biometric residence permit into a website to generate the code. They can then give this code to the employer so that the employer can carry out the right to work check online. However, a share code can only be generated using an eVisa or biometric residence permit. So if an individual derives their right to work from another source, such as their British or Irish citizenship, then they will not be able to generate a share code and you will not be able to carry out an online check. The main alternative to the online checks is to carry out manual checks of documents. Now, during the COVID-19 pandemic, these checks could be carried out over a video call. However, these adjusted checks were ceased on the 30th of September 2022, and now all manual checks must be carried out in person, face-to-face. There is Home Office guidance called Annex A, which sets out the documents that can be used for these checks, and this guidance can be accessed online by searching for Right to Work Annex A. Please note that under Annex A, biometric residence permits are not acceptable as right to work documents for manual checks. Employees with biometric residence permits must therefore generate a share code to prove their right to work status online, as explained. Returning to manual checks, the employer must check that the documents in question are genuine and that the photographs of the individual on the identifying documents match their appearance in real life. The employer must also confirm that the right to work status granted by the document has not expired, and that any restrictions that apply do not prevent the individual from doing the intended work. If there are differences in the names used across the documents, then this must be explained, and supporting documentary evidence must be provided and checked. So, for example, a marriage certificate to explain a change in surname. Having carried out the checks, the employer must then keep copies of all documents checked. These copies must be retained throughout the individual's employment and for at least 2 years after the end of their employment. A relatively new option is to engage the services of an identity service provider, or IDSP. IDSPs use identity document validation technology to confirm that the documents used to prove right to work status are valid. The Home Office published a list of certified IDSPs, and while there is no requirement for employers to use a certified IDSP, it will provide more assurance that the IDSP is doing things correctly. Now, the IDSP option is still relatively new, so it is worth weighing up the pros and cons. On the positive side, the Home Office hopes that IDSPs will reduce human error in right to work checks, and for some employers, engaging an IDSP to carry out bulk checks may be more cost effective than the admin involved in the employer carrying out the checks itself. However, IDSPs do charge fees for their services, and these fees are often structured in such a way that it is only worth engaging them if you require a large number of checks to be carried out. And further, employers still need to carry out due diligence to satisfy themselves that the IDSP is carrying out the checks correctly, and they do need to retain copies of these checks. So using an IDSP does not completely eliminate admin costs for employers. And the scope of using IDSPs for right to work checks is also relatively limited as it stands, as currently IDSPs can only be used for checks on British and Irish passports. So you can't use an IDSP if the individual derives their right to work from another source, like indefinite leave to remain or a visa. Now, there may be some circumstances in which the aforementioned options are not available. For example, if an employee is waiting for a decision on their visa extension. In situations like these, you can use the online employer checking service, provided that you have the employee's permission to do so. You would need to provide the employee's personal details, including their full name, date of birth, nationality, home address, and any Home Office reference number or case ID. These details should be provided on the ECS site, along with the employee's job title and weekly working hours. If the individual does have the right to work, you will be sent a positive verification notice. This provides you with a statutory excuse to employ the individual for 6 months, and that should be enough time to cover most visa decision processing periods. Please note that where a migrant worker's visa has already expired and they are renewing their visa or obtaining a new visa in order to work for you, you must obtain the positive verification notice within 28 days after the original visa's expiry. Right to work is also relevant to some other less typical scenarios that employers might come across. Workers on sponsored visas, such as skilled worker visas, are sponsored by their primary employer to do a specific job, but they may also engage in supplementary employment for a secondary employer, subject to certain strict conditions. For skilled workers, their supplementary work must fall within a narrow category of skilled occupations, a list of which can be found in the immigration rules, and the work must not exceed 20 hours per week, nor take place during the employee's contracted hours for their primary employment or sponsored employment. Therefore, when carrying out your right to work check and confirming that an individual has the right to do the work in question, you must confirm whether they are going to be doing supplementary work, and if so, you will need to ensure that this work meets the requirements mentioned regarding type of role and working hours. for example, by requiring them to provide you with a letter from their primary employer or sponsor. If you employ someone to do supplementary work in breach of these conditions, then you may be liable to a penalty for illegal working. Next, students. Not all international students are entitled to do work while in the UK, though some students are allowed to do a limited amount of work, details of which will be set out on their BRP or eVisa. Often, the amount of work that a student is entitled to do will depend on whether it is during term time or not. Now, if your right to work checks reveal that a student employee has limits on their working hours during term time, then you should require an email or letter from the student's university confirming details of their term times so that you know what the student's maximum weekly working hours should be at different times of the year. This email or letter should then be retained along with the right to work check. If a student is instead joining you for a work placement, then you must obtain a letter from their sponsor confirming that the work placement forms an integral and assessed part of the student's course and does not breach the restrictions on work placements. The letter must also set out the terms and conditions of the work placement, the work that the student is expected to do, and how and when they will be assessed. You should retain a copy of this letter along with your right to work check. Now, as explained, it is very important that you do your right to work checks correctly and in accordance with Home Office guidance, and that you take all extra steps as may be required, as with students and those doing supplementary work, or you could be liable for a penalty. Illegal working is where an individual does work where they did not have the right to work, or they work in breach of the conditions of their visa. If you employ an individual who you know, or reasonably ought to know, doesn't have the right to work, or is working in breach of their visa conditions, then your business could be liable to an unlimited fine, and you could even receive up to 5 years in prison. Even if you are not aware nor have any reason to suspect illegal working, if you fail to carry out your right to work checks properly, then it is likely that you'll be fined at a fixed rate. These fines recently tripled, and it is now £45,000 per illegal worker for a first offence and £60,000 per illegal worker if the business has previously offended. So we're going to go to a poll quickly on the level of fines issued, level of penalties issued. So in the period between the 1st of April 2024 and 30th of June 2024, what do you think the amount of illegal working penalties issued to businesses in the UK was? So was it £450,000, £2,965,000, £8,125,000, or £21,485,000? And I'll give you a moment to give your thoughts on that. Okay, so most of you said £8,125,000. We've also got a few saying £2,965,000 and a few for the other options at either end. So actually, in the period between the 1st of April and 30th of June of this year, 568 penalties were issued, totaling £21,485,000. So it was option D. And for comparison's sake, between the 1st of January and 31st of March of this year, only £8,120,000 worth of penalties were issued. And that means that the total financial amount of the penalties issued per quarter has more than doubled in just one quarter. And in some cases, individual businesses were fined as much as £180,000. Now, we suspect that these increased figures are a result of an increased number of Home Office raids and a greater focus on enforcement action, which the Home Office have been promising for some time. These financial and criminal sanctions are not the only potential consequences flowing from illegal working, however. Further to a raid in 2023, 2 illegal workers from Bangladesh were discovered at the Naga Indian restaurant in West Wickham. No right to work checks had been carried out on these workers, and as a result, the restaurant's sole director was disqualified from being a director for 6 years. Naga was also issued with a financial penalty, and the business has since gone into liquidation. And if your business holds a sponsor license, then it is especially important you carry out your right to work checks and keep comprehensive records of these, as a failure to do so could well lead to the revocation of your sponsor license and the loss of all of your sponsored employees. With that in mind, I'll now hand over to Imelda to speak more about compliance issues in the context of sponsor licenses.
Thank you very much, Callum. Right, I'm going to talk to you now about compliance. So compliance checks, audits or assessments may be conducted by the Home Office on registered sponsors at any stage during the licence validity or on prospective sponsors at the licence application stage. So why should sponsors be concerned about sponsorship? Well, the Home Office have said that sponsorship is considered a privilege and they place great trust in sponsors to undertake obligations in accordance with immigration law and guidance. There has been a sharp rise in the number of sponsors since registration, since Brexit, with now over 100,000 businesses on the public register. Now, of course, the Home Office cannot physically check all of these sites, but they do undertake checks through visits, assessments, or requests for information to ensure sponsors are maintaining compliance with their duties. Now, this year, in addition to those huge right to work increases, we've also seen a dramatic increase in suspensions and revocations of sponsor licenses. So this year, in just Q1 and 2, we saw 833 licenses suspended and 709 revoked. Now compare that to last year. For the complete year, we saw 569 suspensions and 337 revocations. So again, the figures are showing that compliance action is doubling. I'd like to move on straight to a poll just to assess the number of sponsors in our audience. So the first poll is quite simple, is are you a registered sponsor? Selecting yes or no. I'll give you a moment. Oh, fabulous. We've got 50-50 there. Okay, moving straight into the next poll, please. Of those of you that are registered, have any of you had any compliance visits, assessments, or any requests for additional information in regards to compliance? Again, just please select yes or no. Okay, so it's showing that about a quarter of you have had some form of interaction in relation to compliance. That's wonderful. Thank you very much for your interaction. So the first thing I want to do is just to recap on what sponsor duties are. So there are 5 key areas of responsibility that the Home Office expects sponsors to comply with. This is all immigration law and guidance, wider UK law, such as employment law. There is also a public test for sponsors not to engage in actions or behaviours that are not conducive to the public good. There is record keeping duties and finally reporting duties. So looking at assessment, how does the Home Office conduct their assessments to ensure sponsors are compliant with these 5 key areas of responsibility? Well, there are on-site visits. This is the most common way for the Home Office to assess compliance. Now, these type of visits may be announced or unannounced, so it's really important the key personnel contact details are up to date, particularly the authorising officer. Many of the visits are unannounced, as the Home Office do not want sponsors to change their working practices or their environment solely for the visit. I will look in a little bit more detail on the next slide about specific on-site visits. Another way to assess a sponsor is to ask for additional information, either through a pre-license assessment questionnaire or a follow-up request for information. Now, this is most common for prospective sponsors at the time of assessing their license application. At that stage, the Home Office may ask about how the organisation maintains their records, ask for verification about understanding reporting duties, sponsorship law and guidance. They may also request to review staff lists, job descriptions and employment contracts. Now, looking at some of the triggers for a visit. Some factors that could trigger a visit is the sponsor is in a high-risk sector, such as hospitality, care, or retail or construction. Some triggers may be as a result of an online check or report, information within the public domain. It may also be that civil penalties for illegal working have been assessed against the organisation, or there's some evidence of criminal activity. For existing sponsors, it could be a sudden increase in a demand for certificates of sponsorship. It could be that business restructures have not been reported, or staff are completely working remotely. There could also be information gleaned from visa applications from an employee or their family members. Or it could simply be a tip-off from a third party. I will now look at what you can expect from each type of visit, as they will differ slightly. So as I said earlier, the visits may be unannounced, but normally the authorising officer will receive a telephone call to arrange a time for a visit, often the evening beforehand. Visits can sometimes be postponed if the authorising officer is absent, but that will really depend on the trigger for the visit. The Home Office may insist on interviewing another member of key personnel, such as a key contact. Again, it's really important that contact details, particularly telephone numbers, are kept up to date on the licence portal. If it's a visit for a prospective sponsor, so during the licence application stage, the purpose of this visit is to assess the speculative sponsor's suitability for registration and to ensure it's capable of fulfilling all of the obligations of sponsorship. The Home Office generally will assess whether there is any possible threat to immigration control. This can include the issue of civil penalties for illegal working, criminal activity, amongst others. It may also be to assess a specific sector. Now, recently, the care sector has been under scrutiny because unscrupulous sponsors in the care sector have brought workers into the UK where they have had no work to provide those workers, and those sponsors have since had their licences revoked. Now, unfortunately, these workers will be required to leave the UK unless they can find alternative work. So the Home Office in specific sectors may automatically demand an on-site visit to assess whether that organisation is a suitable candidate for sponsorship. They may also want to review the information contained within the licence application. The Home Office now will accept copies of documents, so if they insist on an on-site visit, they may want to review original documents that have been provided as part of the application. They may also want to review information contained from regulatory bodies such as HMRC, DWP or the CQC. They will certainly want to interview key personnel to ensure they understand the responsibilities of sponsorship. They may also want to inquire the business reasons for the licence and whether the organisation can in fact offer relevant employment at the skill level and appropriate rates. They may also ask about the rates being paid to existing employees who are not sponsored to compare whether migrants are perhaps having their salaries inflated just to meet the salary requirements of the visa routes. And they will certainly assess HR processes to ensure speculative sponsors are capable of managing the reporting requirements and the document retention requirements. For example, right to work documents for all workers. And they may also ask to review internal systems just to assess how you can manage these responsibilities. Now, in the post-licence, this visit will assess the sponsor, ensuring they're able to maintain compliance with their duties and do not pose any threat to immigration control. This visit will usually be much more complex than the pre-licence assessment. Quite often, a post-licence visit will be a trigger as they had received information in relation to the sponsor. It could again similarly be to as a pre-licence visit that there have been civil penalties issued for illegal working or there's some evidence of criminal activity. Again, it could be a third-party tip-off or information contained within the public domain, which could be the organisation website, social media, or again from visa applications from employees or family members. The caseworker will certainly want to interview key personnel. So the key personnel are expected to understand the business operation, to discuss reasons for sponsoring migrants, whether the number of certificates requested that has been granted are justified for the size of the operation. They will also want to interview workers. So it's really important that the migrant is undertaking the duties as reported on the certificate of sponsorship and that they are in a genuine role. It's also important that the migrant's work address is recorded correctly on the certificate of sponsorship and that the relevant work address is where they actually are. Any additional sites that the migrant worker may be working on should be included as an additional site on the licence. Caseworkers can also turn up to third-party sites, so it's important that if your workers are on a client site, that this is recorded accordingly, and also that your clients are aware that they could have a visit from a Home Office compliance officer. In terms of assessing HR processes, they may want to have a deep dive into the HR processes to ensure that recruitment records are being retained for sponsored workers if they were to fill genuine vacancies. They may also want to review how holidays and absences are being recorded, ensuring they're in line with your handbook policies. They may also wish to assess whether your sponsored workers are complying with their visa conditions. Callum mentioned earlier about the visa conditions for students. They may want to assess how many hours your students are working and whether you're retaining relevant information in relation to what they're enabled to work. They will certainly want to review documents, particularly contracts of employment, job descriptions, the right to work checks for all employees, any changes that you've had in relation to the workers' duties or job descriptions, ensuring these have been recorded appropriately on the sponsorship management system portal. And finally, they will want to look at payroll records, ensuring that migrant is paid in line with the requirements of the skilled worker visa, if that's the visa they're on, and in line with what you recorded on the certificate of sponsorship. So it's important that any allowances that have been recorded are all set out in payroll details. Now, these visits on both a pre-license and post-license can appear very informal, but please ensure you may remain polite, answer only the questions you're asked, and provide any information that is requested and relevant. Now, quite often when I've attended an on-site visit with a sponsor, the Home Office have asked for lots of information afterwards. So in addition to what they asked for to view on site, they may ask for follow-up information. So the key is to be prepared. Ensure you have robust HR systems and processes for monitoring immigration status, migrant tracking and monitoring, particularly in line with handbook policies. Holidays are reported, absences are reported, reporting any changes in relation to the migrant, and ensuring they're linked to a disciplinary policy. If your migrant is expected to report information to ensure you maintain compliance with your sponsorship duties, failing to do so should be attached to disciplinary process. Ensuring recruitment policies and data is retained to support any vacancies you have filled with migrant workers. Ensure your key personnel have access to the sponsorship management system and that they've not moved on. Quite often it happens that a level 1 user has moved on and there is no access. Ensure there is no sharing of passwords. Key personnel ensure their contact details, that's emails and telephone numbers, are up to date on the portal. And key personnel should know where all documents are retained in relation to the sponsor license and sponsored workers. They should also know who is sponsored and who the users are on the sponsorship management system, ensuring they're familiar with sponsorship duties and reporting timelines. Maintain accurate files for migrants, maintaining their contact details and work locations. Maintain all of the documents as required under the guidance, all mandatory information, right to work, references, DBS checks, pay slips, etc. And again, ensuring all changes have been reported in accordance with the guidance and held on their file accordingly. You could carry out a mock audit. We can assist you with this. Mock audits can help identify and resolve any areas of non-compliance and avoid those hefty civil penalties or potential criminal sanctions that Callum spoke about earlier. Now let's look at some of the discoveries the Home Office have made at the assessment stages, which includes on-site visits, requests for information, and assessment questionnaires. So in terms of salary and fees recovered, sponsors were found to be recovering costs for migrants under the immigration skills charge and the certificate of assignment fees. These cannot be passed on to your sponsored migrants. They will ask to see payroll details. Some of the sponsors were found topping up salary with living costs, which meant that the salaries were not in line with the salary requirements for the visa route. Under genuine vacancies, they found that migrants were undertaking duties that were not part of the role or not recorded in the certificate of sponsorship or not part of their job description. They also found recruitment records that were different to the roles that the migrants were being sponsored for or have filled. In terms of monitoring immigration status, they found that some sponsors had no records of visa start or expiry dates, or they were recording the wrong visa dates. So as an example, a BRP date was recorded as an expiry date instead of using the right to work share code date that they found on the online check. Or they failed to show right to work checks for all staff. Under the record keeping, they've also found many faults where sponsors were failing to report absences for sickness and holidays, or they didn't fall in line with the handbook policy, or where sponsors failed to update the sponsorship management system with work addresses for migrants. I highlighted this earlier. It's really important that if a sponsor turns up on a site and your sponsored worker is recorded as being present, they should be there or working from home, but they should be at the site as recorded. Contact details were also found to be an issue where the sponsor was not keeping a history of contact details or failing to amend work start dates. It is important that you as sponsors retain a history of contact details, not just overwriting it with their current details. And the Home Office have found a number of pieces of information from interviews. So where employees were not given statutory holidays, where no DBS checks were conducted before employment. I think one sponsor that was interviewed said that they use the migrant system as an alternative from recruiting within the UK. So they had action taken against their licence. Now, some of these compliance issues may appear negligible alone. However, cumulatively, they could result in serious sanctions against the licence, the sponsored workers, and potentially key personnel. So let's look at the impact of non-compliance. Now, if the non-compliance is discovered during the pre-licence assessment stage, it is unlikely the licence will be granted. If it's discovered during the post-licence stage, the licence may be granted. However, it may be downgraded from an A rating to a B rating. The sponsor, if they are downgraded, will not be able to issue new certificates until improvements have been made and they're upgraded after an action plan. However, they will be able to issue certificates if their employees need extending. They must agree an action plan, pay a fee, and then demonstrate the improvements before the licence is upgraded back to the original A rating. The Home Office may move to suspend a licence if they discover there are numerous breaches in sponsorship duties. And now in these circumstances, the sponsor cannot assign any certificates. They must continue to comply with their sponsorship duties. Usually the sponsor will have an opportunity to address any non-compliance issues in a follow-up letter together with supporting evidence. The Home Office will then assess all of this evidence and information and provide a response within 30 days. They may not support reinstatement. They may then move to revoke. The Home Office may revoke a licence immediately if they discover a sponsor has ceased to have or have never had a trading presence in the UK, if they cease to meet the requirements of the route in which they're licensed, or if they discover serious or systematic breaches of sponsorship duties. They may also move to revoke immediately if they see the sponsor poses a serious threat to immigration control, or if any of their key personnel have been convicted of a relevant criminal offence. If a sponsor or any of their key personnel have breached the public test, which means they have engaged in behaviour or actions that are not conducive to the public good, they may also move to an immediate revocation. Now, if the sponsor has the licence revoked, those migrants will have their leave curtailed once they have a curtailment notice to 60 days, unless they find suitable employment within the UK. If during a licence assessment or a visit, the Home Office discover illegal working, the sponsor could face penalties of up to £60,000 per illegal worker, and any business who employs or knowingly employs an illegal worker could face a term of up to 5 years imprisonment. Now let's move on quickly to another poll. So I covered this a little bit earlier. So what Home Office fees must not be passed on to a sponsored employee? Is it the immigration healthcare surcharge, the immigration skills charge, a visa application fee, or no fees can be passed to the sponsored employee? I'll give you a moment to make your selection. That's a very interesting result. We have 29% saying the immigration skills charge, and then a whopping 71% to say no fees can be passed to a sponsored employee. Well, in fact, I covered it a little bit earlier, and the immigration skills charge cannot be passed on to your employee. Where the Home Office have undertaken visits, they have found that employers, sponsors have passed this charge on, they've taken action against the licence. So it's really important to bear that in mind. Some fees can be passed. You can ask me about it later if you wish to know which fees can. Okay, let's move on now to have a look at what we may have in 2025 and beyond. So firstly, looking at the government plans, the Labour government plans. Next slide, please. Well, the Labour government plans are not too dissimilar to the Tory government before them. There remains a focus on the reduction of net migration, the mantra that has been with the previous governments for the last 10 to 15 years. The Labour government do, however, want us to reduce reliance on overseas workers, instead focusing on upskilling the national workforce. However, there are no plans on how this will be funded as of yet. They do want to focus on clearing the asylum backlog, providing additional resources to do so. They also want to increase the returns. So once the asylum seekers have exhausted all routes to the UK, they want to ensure that they are returned and they don't remain here being funded by the UK taxpayer. One of the first things the Labour government did when they came into office is to undertake, ask the MAC to undertake a review of the IT and engineering sectors to see why the UK are so heavily reliant on these sectors. Now, we don't expect to see the results of that yet. We hope to see more about it next spring to see if there is a real reliance on these sectors in the UK. So we expect to see more, when they've settled into office. The visa vignettes will be reduced to a 30-day issue. During COVID, these were increased to a 90-day validity to allow workers to come to the UK once their visa had been approved. However, we expect to see a 30-day issue reduction from the start of next year. We haven't had a date confirmed yet, but we expect it to be from next year. Sponsors, you'll be delighted to hear the long-awaited new IT system will be moving into a test phase with the government-authorised exchange sponsors, which is a small subset of sponsors. Now, we don't know the full implementation date yet, but we expect any TV issues to be discovered while in the testing phase, so that when we do move all sponsors to this new amazing IT system, it will work beautifully. The current system, for those of you who have been using it, has been in place since 2008. It's pretty archaic and inflexible, so we wait in anticipation for the new system to come into force at some time, hopefully next year. The electronic travel authorization, or the ETA implementation, is operational for a number of countries for some time. So Bahrain, Kuwait, Oman, and Qatar, Saudi Arabia, and the Emirates have been in place for some time. Now, this process will be extended for all remaining non-visa nationals, except for Europeans, on the 27th of November. So those individuals can apply and then travel to the UK after the 8th of January 2025. The application process will then open on the 5th of March for the rest of European nationals for travel to the UK on the 2nd of April 2025. So from April 2025, all visitors will require applying to the ETA before they arrive to the UK. Now, unfortunately, individuals who have had former visa refusals or certain criminal records or any other immigration issues may need to apply for a visitor visa before coming to the UK. Now, this could add additional cost and timing for travel planning to the UK, so please be aware of that. Now, let's look at a summary of what we've spoken about today. Earlier today, Victoria spoke to you about eVisas, reminding you that BRPs, or physical documents, are discontinued from the 31st of December 2024. We are moving to a fully digital system by the 1st of January 2025, and for employers to support their employees with the switch to eVisa, as we do know there have been some teething problems. With right to work checks, please review your right to work checks for existing employees, and note that you may have to repeat checks for eVisas. So please do conduct a review to see who you need to conduct those checks for. And in terms of compliance, please review sponsor compliance, and if you can, conduct a mock audit to ensure you are remaining compliant with those sponsorship duties. So now we will move on to any questions you have posed through the course of the webinar. I see we have some in the chat box. Right. Callum.
There's one here on right to work, Imelda, which I don't mind taking on
Sure.
the checks for self-employed people, asking whether the requirement to check right to work is just for those self-employed who may be sponsored by the company in future, or if it's all self-employed people. It's an interesting question because this is a entirely new element of the guidance on right to work checks that came into place in September of this year, as I said, and all that the guidance says is that you must still carry out these right to work checks on self-employed people to comply with your sponsor duties. Now, it's clear that you won't be liable for a penalty for illegal working if you don't carry out these checks, but you do need to carry out the checks to comply with your sponsor duties. Now, it's not entirely clear why it would be necessary to carry out these checks on self-employed people for the purposes of complying with sponsor duties. Why there would be a need to do that, but that is what the guidance currently says, and so that's why we felt it was important to flag that as it stands, the current position from the Home Office appears to be that if you are a sponsor, you do need to carry out right to work checks on self-employed workers and agency workers. Now, of course, if you were going to be sponsoring somebody in future, if they were going to be coming on board as an employee, then you would need to carry out right to work checks regardless, and there would be the potential for illegal working penalties.
Interesting, yeah. Thank you, Callum. That was an interesting change to the guidance earlier this year, indeed. And I think, yes, something that needs to be highlighted. We have another question. If you recorded a right to work check for an employee as expiring on the 31st of December with a BRP, do you need to repeat the check?
So sorry, could you repeat that, Imelda?
If you record an individual's right to work check as expiring on the 31st of December with a BRP, do you need to repeat the right to work check?
Yes, so my understanding is that you would need to, because essentially, as the check is presented, it would appear that the employee does not have the right to work beyond the 31st of December, and that's why the recommendation is to repeat all checks for those employees who are transitioning across to eVisas.
Okay, so I think the important message here is if you undertook a check using a physical document, such as a BRP, and that was dated the 31st of December, effectively your check would have been to the 31st of December. Then the check must be repeated once the individual obtains an eVisa, because the eVisa would then show the actual expiry of their visa as opposed to the expiry of the document. Yes, that's.
Thank you, Imelda. I've just said we've got a few minutes. I think we've got a few questions about eVisas as well in the chat box. The first one, we are an international company and have some third country nationals travelling to the UK via the standard visit on business visa. Do they need to switch to eVisa if they hold a physical one in their foreign passport? Now, visitors who will be in the UK for less than that 6 months, so on that standard visit to business visa, won't get access to an eVisa, so you don't need to worry about that switch. And it's my understanding that they should continue to use the physical passport visa rather than the eVisa system. We've also got a couple more, just getting these up. Regarding checking for an eVisa, how else can we prove that the employee does have an eVisa in place? Well, the first one will obviously just be to see if they can give you access to the View and Prove service. They can share that with you. Obviously, Callum went over the various implications in respect of right to work and what you'll need in respect of doing that. And I think, Imelda, have you got anything else to add on that one, or?
No, I think it's important that you can only undertake a right to work check using 3 of the options that Callum mentioned earlier. And moving forward, it will ordinarily be a share code with the date of birth for your employees to be undertaken before the employment commences.
Perfect.
Wonderful. Okay, I think we're right on time. So what I would like to do is now just finish up really. If we can just move to our contact details. We have provided our QR codes for our LinkedIn. We share content regularly on LinkedIn, so please do connect with us. Please remember to stay on to complete the feedback form, and this will automatically appear at the end of the webinar. However, I think my colleague is going to send it to you later. Those who complete the feedback questionnaire will be entered into a prize draw for a £50 John Lewis voucher. So now I'd like to thank you on behalf of Callum and Victoria for your presence today, and I hope you found this useful. If you have any questions, please feel free to get in touch with us, and thank you very much again. Take care.
Thank you all. Bye.
Bye.